Well, Ayla Washington, good afternoon and welcome to our webinar. This was a very fast turnaround webinar that we put together to deal with the DHS rules that went into effect, or sorry, were published rather, last Wednesday, and will be going into effect unless they're enjoined by one of the many, many lawsuits challenging them on October 15th later this year. By way of disclaimer, I'm of course speaking to a lot of more experienced chapter members. I don't by any means pretend to be the expert on all things public charge related, but I've been taking a pretty close look at these rules since they were published in draft form last year. And I've been through the final rules with some detail since they were published last week. So we will go through briefly, I don't want to spend a lot of time on it, the current standards governing public charge inadmissibility. And it's been the bulk of our time talking about the new rule as proposed as finalized last week. I'll try to tease out for folks who are familiar with the draft rule, some of the changes that went into effect between the draft and the final rule. We'll then finally talk about public charge bonds, which are a new thing under the final rule, and go through some specific recommendations. These aren't just from me, also from Clinic, who's done some great work on this issue. In terms of logistics, I've kept everybody on mute purposely because with 65 participants, it's going to be crazy if people are off mute. But if you go to the top of your screen and select the drag down menu and select more options, you'll find that you can open a chat dialog, and that will let you chat with the other participants and with myself. Since we have a lot of material to get through, I might not do a bunch of questions on the fly. I'll certainly try to get to them either at the end of the webinar, or else I'll respond on the listserv later, or you might get better answers from the other participants. Again, I use the chat function by going to drop-down menu and selecting more. Okay, current rules governing public charge inadmissibility. Final disclaimer is I'm dealing with a really nasty end of summer cold, so you may hear me slurping on water as we get through this. So as folks know, it's been the case since long, long ago that there's been something in US immigration law requiring self-sufficiency as a precondition to immigration. And the current language that we have in the statute has been in effect again for quite a long time and prohibits the admission of those deemed, quote, likely to become a public charge. Now, although that's the standard, there's been no definition in the Immigration and Nationality Act as to what it means to become, to be likely to be a public charge. And instead, the INA lists these factors as to be considered by a consular officer or a now CIS adjudicator. Those folks are to look at age, health, family status, assets, resources, and financial status of an immigrant, and education and skills. And preview of what's to come later in this webinar, it is those factors that get renewed attention by DHS. So by large measure, the new rule fleshes out that multi-factor test, and depending on your viewpoint, contorts it into something that is far broader than the statute itself. In addition to that multi-factor test in the statute, of course, it has long been the case that a US petitioner could execute an affidavit of support promising to maintain the financial well-being of the intending immigrant. Folks may know that this is my practice area of focus, is representing beneficiaries of the affidavit of support. Now, prior to 1996, of course, those were not enforceable, and that changed with the passage of IRA-IRA. IRA-IRA made those affidavits binding by both the immigrant and also by a state, federal, or local entity that pays means-tested public benefits to the intending immigrant. So the sponsor has a legally binding obligation that can be enforced either by the immigrant or those government entities. And more or less, those are required in all family-sponsored cases, with the limited exception of those listed on the I-864W. I mention this background because this 1996 legislation was really the last time that there was a substantial change in how public charge was handled. Basically, the 1996 legislation is Congress saying, okay, we have, or we perceive to have a problem with public charge inadmissibility. We note that these affidavits aren't actually enforceable. So our solution is that we are going to make them enforceable by the beneficiary, and hopefully that puts some teeth on public charge rules. The I-64 was intended to put the onus on the sponsor rather than the American taxpayer to make sure that the immigrant was supported. Of course, concurrently with the 1996 immigration legislation, rules for means-tested benefits were also tightened such that most lawful permanent residents have to wait for 5 years of residency before they qualify for federally funded benefits. I mention that because that will turn out to be important for a new focus on public benefit programs that are now baked into the DHS rules on public charge. Now, in terms of the actual guidance on the ground from legacy INS, now in effect for CIS, we have a 1997 field guidance memorandum that, for all intents and purposes, doesn't really rear its head in adjustment adjudications. That's the reality. And it says that it means to be likely to become a public charge means primary dependence on one of these three programs: SSI, TANF, or General Cash Assistance Programs. Those are administered by states. And also institutionalization for a healthcare issue at government expense. That's also on the list. But I mean, this is editorializing, but the reality is for adjustment applications that by far the focus for practitioners and adjudicators is on the affidavit of support. You know, if we have any issues that we're worried about at the consultation stage, it's usually about, okay, is the income of the primary sponsor sufficient? Does he or she have assets that we can use to make up a shortfall? Oh gosh, these assets are weird. Can they be converted to cash? Can we get a joint sponsor? That's legitimately the focus of public charge when it comes to adjustment applications. And that is going to change. That is the primary thrust of the new DHS rules, is that a valid I-864, which to most adjudicators has been sufficient to overcome public charge admissibility, will now be necessary, but never in its own right sufficient to overcome public charge admissibility. Before turning to the new rules, I just want to briefly mention what's going on in the consular processing arena, because this may foreshadow what we begin to see as DHS implements its new rules. It used to be the case that public charge refusals, visa refusals, this is in immigrant visa cases, based on public charge, were pretty rare. So we're talking about under 2,000 refusals back in 2015. That has massively skyrocketed in the past 3 years, such that we now get in the field of 14,000 refusals. Okay, well that's bad, but what's scary is that people are now not overcoming those refusals. What really was happening back in 2015 in immigrant visa cases was that people would get initial refusals on public charge grounds, but that actually just meant that they screwed up something with the affidavit of support. So something wasn't properly documented or misreported, and then they would go out and change that, or they would get a joint sponsor, and that would all be well and good. So that is now what is changing. And now you get closer to only half of people who are able to correct the public charge issue in their case. And that's because the Department of State has instituted changes in the Foreign Affairs Manual that do something similar, although not as draconian as what the new DHS rules do. The FAM rules basically minimize the affidavit of support and allow the adjudicator to look beyond the affidavit of support. And so what I'm saying is, if we see all of a sudden only 60% of people getting past public charge issues in the consular arena, it might actually be worse than that once the new DHS rules take effect. trying to create a groundswell of positivity in this webinar, as you'll see. Okay, scope of new rule. Who does this even apply to in the first place? And again, as a reminder, if folks want to share thoughts, questions, concerns, just hop over to the chat functionality that's available through the drop-down menu. Okay, so the first thing is for sure a good piece of news, which is that the DHS rules have prospective application only. They are effective to adjustment applications only if postmarked after October 15th, 2019. So many folks have been justifiably concerned that pending adjustment applications would all of a sudden be held to the new standard. And that's not the case. Fortunately, it's only for applications filed after October 15th. So practice pointer number one is an obvious one. If you've got cases you can possibly file before October 15th, do it. And not just folks who are in low income brackets, but anyone, because applicants across the board are going to have a whole lot of extra paperwork to do starting October 15th. And you'll do everybody a big favor if you can get them out the door before then. So, you know, unless we have a court injunction, it looks like we'll have some sort of version of the 245I filing crush where people are justifiably concerned about getting filed before October 15th. Okay, number two in terms of scope, it's a DHS rule. So it does not apply, period, full stop, in consular processing cases until it does, because what's really likely to happen is we've already had the FAM revised. So Department of State was basically ahead of DHS with this crackdown on public charge. They did this in early 2018, I believe it was January 2018. So they've been kind of hopscotching with DHS. Now DHS has finally gotten its case finalized. So what I think a lot of observers believe is going to happen is that we'll see another FAM revision that brings FAM closer into line with what we're seeing here with DHS. So if people are beginning to think about forum shopping to take advantage of what will now be more lenient rules in the consular processing arena, the smart money may be on not doing that because the FAM may get revised in the very near future. Likewise, this of course doesn't apply to Department of Justice, again, until it does. So this is a DHS rule, it's not a DOJ rule. However, DOJ is finalizing its own version of this rule, which is currently at the OMB review stage. So that basically means it's very close to getting published as a proposed rule. And nobody that I'm aware of has very good intel on exactly what that DOJ rule looks like. But you can pretty well bet that what we're looking at here is a rubric that's going to lead to adjustment applications once denied on public charge grounds, getting served with NTAs and being targeted for removal. Also, although this is a DHS rule and CBP is of course organized under the Department of Homeland Security, it doesn't create any new procedures at ports of entry. So you don't need to be advising clients that they're required to bring new forms or documentations when applying at ports of entry. Who does it apply to? You know, the thrust of this rule by far is adjustment of status applications. That's who's going to feel the crush. It also applies to change of status and extension of stay, but the standard that is applied there isn't very tough. Those folks aren't going to need to file any new form in light of the new rule. And the only thing that adjudicators are really allowed to look at is whether those non-immigrants have accepted public benefits while on a non-immigrant status. So as long as you're student seeking a change of status hasn't been on Medicaid or one of the other programs that we're talking about, she's fine. And that's good news because it's not so black and white when it comes to adjustment applications. So again, non-immigrant applications, non-immigrant, applicants get held to a very much lower and easier standard. And a question about how does the 10-year Social Security earnings history exception apply to the new rule? So the standards for I-864 exemption are statutory, and DHS can't mess with them. It does appear to be the case that the I-864W is going to be done away with, and that information is going to be gathered on the 485 and primarily the 485 form. So if you think you're I-864 exempt, that's now going to be reported right there on the 485, but the standards for who's exempt haven't changed. In terms of exemption from public charge and admissibility, these exemptions are of course statutory. So the fact that refugees and asylees are not subject to public charge and admissibility, that doesn't change. It can't because it's right there in the statute. And the list is quite extensive. I put in the chat notes earlier my practice advisory on this, and that cross-references the full list, but folks are probably familiar with this. Nothing changes, it's statutory. visa holders are a little bit of a special case. So in the proposed rule from October 2018, DHS said that T-visa holders could, if they wanted to, affirmatively apply for a waiver of public charge and admissibility. They realized after the public feedback session that that was probably contrary to the Violence Against Women Act. So the final rule says that T-visa holders do not need to affirmatively apply for a waiver of public charge and admissibility, and that DHS, quote, may grant a waiver of that ground. So it's a little bit unclear whether that means that in practice, DHS will simply automatically waive the application of public charge and admissibility to T-visa holders, but at any rate, they don't need to affirmatively ask for such a waiver. And I should note that as to other classes of immigrants, there is no waiver for public charge and admissibility. So if you're a general family-based adjustment applicant, you can't ask for a waiver of public charge and admissibility. Okay, so the focus of the new DHS rule is going to be on a new 7-factor test of public charge and admissibility. And part of that is whether somebody has received benefits from a list of prohibited programs. We'll go through that list now, but one refrain that I think is important to emphasize is that your focus really needs to be not just on these public programs. So in other words, your client doesn't get a pass just because they haven't received benefits under Medicaid. If they have received benefits under Medicaid, that's going to be a real problem. But the list of problematic circumstances is much, much broader than simply whether somebody has enrolled in one of these programs. Okay, so the way it works under the new rule, remember that INA itself doesn't define public charge, but the rules do. So they say public charge now means somebody who receives public benefits. Okay, what does public benefits mean? Public benefits means somebody who has received one of a new list of prohibited programs at a level that is above the de minimis amount. Now I'm referring to these as prohibited programs. They're obviously not actually prohibited. You can enroll in them if you're lawfully able to do so. It's just that you might then become inadmissible. So we'll just call them impermissible programs. So public charge means getting public benefits, but the way that we assess whether you fall in that category of likely to get public benefits is based on the new 7-factor test. Now, one thing that seems very weird about the new rule is that the entire focus now is on forecasting in a magic crystal ball whether an intending immigrant is likely to get one of several programs, including Medicaid. What DHS specifically says it will not do is look at the enrollment criteria for those programs. So does that settle in? So Our job is to decide if this non-immigrant is likely to receive Medicaid. However, we will not consider or look at the enrollment criteria for the Medicaid program. How that makes sense is a little bit past me, but that's what the rule says. Okay, public benefits. The proposed rule created this god-awful taxonomy of programs. And I won't even summarize what it is because fortunately we did away with that in the final rule. The final rule defines receipt of public benefits as meaning receiving them for 12 months or more in any 36-month period. And this is in the aggregate, meaning that if you're enrolled in prohibited program A and prohibited program B for August 2019, you are attributed with 2 months of program enrollment. Does that make sense? So it would be common to be enrolled in TANF and Medicaid concurrently, so you would be getting 2 credited months each calendar month. What's on the list? So we have familiar stuff, SSI, TANF, and then new stuff. SNAP, food stamps is the one that's been getting the most attention in the lay media. Medicaid is on there, although we'll talk about the exceptions in a moment. And then Section 8 and Section 9 housing programs. There are several different programs there. So the new ones, again, are food stamps, Medicaid, and federally funded housing benefits. What is not on that list, and I mention these only because Steve Miller, endless peace and blessings be upon him, had considered these at various points in the rule formation. So WIC, the Women and Children Supplemental Health Program, is not on the list. Obamacare is not on the list. However, there is a major caveat for subsidized care. Earned income tax credit had been considered, but is not on the rule. Medicaid Part D is not on the rule. And institutionalization for long-term care, DHS realized that this last one was basically meaningless because the Medicaid program accounts for everything that would otherwise fit into that last bracket. Melody, to respond to the question about asylum seekers getting food stamps, it's okay for them to do so, not because the benefits are state funded, but because folks who are in valid status as asylees are public charge exempt. So benefits received while they are in an exempt status don't count against them. Medicaid exemptions. So Medicaid generally is considered a naughty program, but there are 5 important exceptions. Emergency Medicaid, IDEA benefits, school-based services, any benefits provided to someone under age 21, and pregnant women. The last 2 are a big win. That was a change made between the proposed rule and the final rule. Now, the important thing to note about this is that remember that under PWORA in 1996, most new residents are not eligible for Medicaid at all. And if they are eligible, it's probably because they fall into one of these program exemptions. Which is to say, if you have a client who's getting Medicaid, it's probably because they're allowed to do so under this rule, either because they're pregnant or receiving school-based services. So that's an important takeaway, and another reason to be really guarded about encouraging clients to disenroll from these programs, because they might very well be allowed to do so even under the new DHS rule. So if clients are asking you about Medicaid enrollment, make sure you're understanding how it is that they're eligible in the first place. Under broad exemptions, this is good stuff. Military families, that's both if the applicant himself or herself is enrolled in is an active duty service member, and also their spouses and minor children. Also, any adjustment applicant who will automatically become a citizen by virtue of residing with a US citizen parent, those folks are also exempt. So the new rule just doesn't apply to them. Other major concern throughout the rulemaking process had been the issue of how DHS was going to handle benefits received by other household members. And the final rule makes clear, and this is discussed many, many times in the preamble to it, that benefits received by household members, that is not imputed to the foreign national member. So if you have US citizen kids who are getting TANF or food stamps, that does not count against your client unless your client is listed as herself a beneficiary on the enrollment paper from the health agency. So that's great news. Sarah, in terms of whether somebody going to Western State Hospital would have a problem, yikes. I don't actually know off the top of my head how Western State funds all of its programs. I'm sure it's a god-awful patchwork of different funding. So you would just need to tease out for sure whether that person was benefiting from Medicaid for their enrollment. 1099 civil commitments, which I think you're referring to, are of course a creature of state statute, but how Western State gets its funding is a different issue. Maybe a non-issue because maybe Western State will end up getting shut down in the near future, sadly. Okay, another, I suppose, piece of good news, if we want to call it that, is that the rule is prospective only as to receipts of public benefits. So it applies only to applications filed after October 15th, and it also applies only to benefits received after October 15th. That's the block letter rule. But then in kind of a bit of bet hedging, DHS also says that it will consider the receipt, application, or certification of benefits received before the October 15th effective date. Those benefits, however, and this is right in the final rule, are supposed to be considered under the existing 1997 guidance memorandum. So the takeaway there should be that if your client, for example, received food stamps, those aren't on the prohibited list under the 1997 memorandum, so that should not be a factor against their future public charge determination. So all of that is just the list of public benefit programs that count towards public charge. That's not really the big issue with the new rule, though. The focus for all of us is going to be getting our arms around a new 7-factor totality of circumstances test. Here we go. So for now, all of our new adjustment applications, we are going to be filing a new 19-page form called the I-944 Declaration of Self-Sufficiency. And think of it sort of as like a new I-864 from hell, except that it's for your applicant. So this is a document in which your client will basically do everything that she can to demonstrate her ability to be self-sufficient, from showing employment history to asset ownership, and a multitude of other factors that DHS thinks is important for that determination. So it will be doing a deep dive into her financial situation. And that's what we'll talk about right now. Documentation that is going to go into this form is really extensive. DHS in their rulemaking process thinks that it will take us 4.5 hours to get through the I-944 form. And let me tell you folks, I think that is nutso. That is crazy. If we end up spending less than half that time, I would be surprised. This is going to be vastly more work for us and vastly more work for our clients than the I-864 form ever has been. We'll have to provide 3 years of tax transcripts if available. There's actually an inconsistency in the rules. Some places it says 1 and some places it says 3, but it looks like 3 is the answer. So 3 years of tax transcripts, that's of course more than the affidavit of support. You have to file a credit report, or if your client is undocumented and doesn't have one, you've got to explain why they don't have a credit report. Documentation of other income. There's stringent rules in the I-944 instructions for asset documentation. So some people are, kind of loosey-goosey and submit like a Zillow printout to show how much a piece of real property is worth. That doesn't cut it. They're going to have to get a licensed appraisal and document the status of their mortgage payments. So you can see that this list is going to be a big old homework assignment for your clients. So the statutory factors are more or less the ones that are regurgitated in the final rule. The first 5 come straight out of the statute. Anticipated period of admission, because as we noted earlier, non-immigrants are subject to the rule and get held to a lower standard. And then you notice way down on the bottom of the list, we have the affidavit of support. So that, pretty substantial document that had basically been the focus until last week is now relegated to this almost afterthought in the public charge adjudication process. Factor number 1, age. So clear preference for working age folks, that's 15 through the statutory retirement age of 65 or 67. That's because, of course, DHS views those people as more likely to be employable. So what this means is that if you have folks, especially above age 67, they are simply going to have a tougher row to hoe when it comes to public charge determinations. They're going to have to be making a steeper showing in the other factors that we'll discuss in a moment. So it's kind of that simple, that being out of that age range is now going to be inherently a risk factor for adjustment applications. Okay, health, this isn't so much of a new deal because already most of us are looking at our adjustment applicants to see if they may have a costly medical condition. And that's simply something that gets renewed focus under the new rule. So DHS is now going to be looking much more consistently and more rigorously about whether somebody has a healthcare condition that's going to be an out-of-pocket expense for them. What they're supposed to be doing under the new rule is relying primarily on the G639. So in most cases, their analysis is supposed to start and end with the G639. Family status. Family status means household size. That's really what it means in the new rule. So the larger household that you have, the higher of a burden you have to pass muster with public charge. No really big surprise in terms of how household size is defined. It's the applicant, the spouse, if the spouse is living there, and then any children or other individuals who are receiving the bulk of their support from an applicant. So really there we're looking at if there's a child support order in place or a alimony order in the case of an ex-spouse. Either of those would count as a household member. So then DHS considers whether the assets and financial wherewithal of the individual. And here there's like a 5 subpart test embedded into this factor in the 7-part test. So there's like a 5-part test and a 7-part test. And the first thing that's looked at is whether the person's income is at or above 125% of the poverty guideline. So that is, of course, the familiar I-864 factor, except applied to the immigrant herself. I'll reserve further comments on that because later we'll talk about what are called the heavily weighted positive and negative factors, which are basically per se adjudications positive or negative on public charge admissibility. The other big news when it comes to looking at the person's assets is that we look at financial liabilities. So as I'd mentioned, DHS will now look at a credit score for the individual. And there's no goalpost there in terms of what's considered a good enough credit score. It's simply that that's something that will be considered by DHS. And furthermore, DHS will consider liabilities that don't count against a person's credit score. So if they have consumer debt, school debt, a mortgage, court judgments against them, that's all going to be considered a negative factor. And of course, again, DHS will look at if the person does have a medical condition, whether their assets may be sufficient to cover treatment, in the future. A big change from the proposed rule, and this is also a departure from the affidavit of support, is that income from unauthorized employment can be counted. This gets a little bit complicated because it appears that unauthorized employment cannot be counted for the heavily weighted factors that we'll talk about in a moment. But just generally, when it comes to the I-944, if your client has been working on a fake SOCH and an I-10, that income actually can count positively towards their general assessment under the I-944 form. So that's good news. Take that for what you will. Next, DHS is going to look at the education and skills of the applicant. So this starts with an analysis of the person's income tax transcripts to see if they've been reporting income. DHS is going to be looking for applicants who have at least a high school diploma. That's not a per se requirement, but that's a positive factor to at least have a high school diploma. You'll need to document occupational skills. So if your client has some certification in welding, or I suppose certified that he or she can type at a certain rate, that all needs to be documented. And a big one, we talked about this when the proposed rules came out, but English language ability is baked in there as a requirement for the rule. Now, I think this is a really big deal potentially, and we just really don't know how this is going to get played out on the ground level. There's nothing in the rule that suggests that adjustment applicants are going to be given a structured test. So we all, of course, know that N400 applicants get that silly quick English language test at their interview. And there's nothing in the rule that even suggests that that will be required. Instead, this appears primarily to be assessed through certificates. So there's no one certificate that's required, but if your client has enrolled in English language courses, proof of that course enrollment needs to be filed. And if they have a certificate of any sort showing English language ability, that also needs to be included. This is kind of good and bad news because, okay, it's good that there's not a strict test to which people are going to be held. On the other hand, that means that the test is going to be the subjective judgment call of a DHS adjudicator, which I'm not thrilled about. If you have folks that you think may present with marginal English language ability, but in fact, when they're not nervous and staring down an adjudicator, do fine, you might want to consider having them do something like the TOEFL or other English language written test to document that, yeah, they actually have pretty good mastery, just maybe sometimes they get nervous in conversation. But this is, worth underscoring as a big deal because there simply is no other place in immigration law, US immigration law, aside from that naturalization requirement for English language. DHS is really cagey and very careful in the final rule to say that this is not a per se requirement. It's just another factor that we'll look at. Again, anticipated period of admission is factor number 6. And this just codifies the view that non-immigrants can be held to a slightly easier standard than adjustment applicants. So again, non-immigrants do not have to file the I-944 form, and as long as they haven't been receiving prohibited benefits, they're supposed to be fine for a change or extension of status application. I'm not ignoring the the questions that are coming in. They're just too long for me to read on the fly. So I'll either try to address those at the end or just shoot out an email later. Finally, the very end of the multi-factor test is number 7, affidavit of support. Now, what DHS does here is a version of what the FAM has done since January of 2018, and that is to basically second guess the likelihood that a sponsor will fulfill his or her support duty. So just so we're clear, an I-864 sponsor signs a document under penalty of perjury attesting to provide financial support to this beneficiary. Under the terms of the affidavit, that's binding. Under 8 CFR, that's binding. Under the text of the INA, that's binding. So the sponsor is now supposed to show through something else that he or she is actually likely to provide the promised support. How you do that, aside from signing a federally enforceable contract, I have no idea. I do think I know who this is likely to be targeted at, and that is joint sponsors. So DHS wants to consider the likelihood that the sponsor is going to do that thing that they promised to do. If you have a spouse who's living with the intending beneficiary, intending immigrant, they're all in the same household, it's a married couple, I don't think that's who's going to be targeted here. But what we've seen at especially CDJ is the problem with joint sponsors. And if your joint sponsor is not closely related, doesn't have a history of providing financial support to the family, and you've just managed to get poor Uncle Joe living in Montana to sign some piece of paperwork that he probably doesn't understand, that's now going to be a problem. And those people, the ones with joint sponsors who really aren't in the picture, financially speaking, those are now going to be really problematic under the new rule. When I see this 837-page document from DHS, what I see is a ton of room for discretion. So we've got multi-factor tests embedded in multi-factor tests that basically look at everything you can imagine about an applicant, which is to say that if you have somebody who's in that gray zone, and we'll all have to figure out over the next period of time where that gray zone even is, but if you have somebody in that gray zone of low income folks, even moderate income folks, DHS is going to be able to find something somewhere in that quagmire to go one way or the other on a public charge adjudication. I'm just saying that the rules give a lot of latitude for DHS to find some negative factors somewhere and to weigh that against the applicant, because there's no arithmetic formula for how these factors get weighed. It's not an algorithm. So if the DHS adjudicator wants to weigh factor 4 subpart 3 a particular way, it's going to be very difficult to challenge that. Eunice, in terms of application of I-944 to consular processing cases, it's not required for consular processing cases unless the FAM revisions later say that it is, but not for now. So that was the general multi-factor test. Smeared on top of that, like a slightly too old mayonnaise, are these heavily weighted factors. Now, DHS is careful to say that these heavily weighted circumstances do not result in per se public charge determinations one way or the other. But I think it's pretty safe to think of them as basically doing that. So first, there are heavily weighted negative factors. So again, DHS says that these circumstances do not make you per se inadmissible, but I think that's basically how you should think about them when it comes to client counseling. So if your client is not a full-time student and is authorized to work, doesn't have a good employment history, or demonstrated ability to get employment in the near future, that's basically a per se public charge issue. One piece of good news here is that the final rules, unlike the proposed rules, carve out an exception for primary caregivers. That's a big deal. So the previous rules had nothing in there. So if you had an unemployed stay-at-home father, he was going to be in a lot of trouble. Now, as long as you can document that you are a caregiver for a child or an individual with a disability, that will be a factor that DHS will consider. The rule on that in the I-944 instructions is a little bit weird and suggests that the documentation you might need for that includes a court order, which of course most stay-at-home parents don't have, but you would need to prove it one way or the other. Excuse me, I'm going to take a sip of water here. So bottom line for heavily weighted factor one, lack of strong employment track record, big problem. If you have currently received or received in the past public benefits, that is a basically per se inadmissibility. Now again, that means receipt of one of the programs we discussed for longer than 12 months within a 36-month period. This is pretty similar to the existing rule. If you have a medical condition, so for example, long-term cancer care, requiring treatment that will prevent you from working, that is a big negative factor. I don't minimize this, but it's just that the folks who are primarily going to be impacted by this were already problematic under the existing rule. Fourth negative factor is a weird one. The proposed rule would have said that any prior public charge inadmissibility finding led to another finding. The final rule limits this to findings by immigration judges or by the BIA. I have no idea why it was changed this way, but that's how the rule is written. So if you have a case that included merely a prior finding by a consular officer, it doesn't fall under this per se rule. Those were the negative factors. Positive ones are the following. Number one is if the applicant's household income is at or above 250% of the federal poverty guidelines. Now, probably above everything else that we've talked about so far, this is going to be a thing that will be a focus, at least at my firm, for how we look at new clients. Which is to say that right now, of course, for everybody who comes in the door, you want to make sure that you've got a sponsor with income at or above 125% of the federal poverty guideline. And you're probably counseling your clients now that if they're above that level, they're probably fine. I think it's now more or less the case that that analysis now applies to people who are 250% or above. So if you are above 250%, and unless you have a really strong negative factor, like an expensive healthcare condition, or of course, something like receipt of public benefits, then you're probably going to be safe. So this is like the new safe zone for the I-864. I mentioned earlier that unauthorized income could be counted on the I-944, and that is true. However, it appears that it cannot be counted towards this heavily weighted positive factor because it is clear that, next slide, only the applicant's authorized income can count. So it's fine if you have unauthorized income, but it just won't get you to this safe zone of 250%. Third positive factor was added at the final rulemaking stage, and this is health insurance. But it comes with the big caveat that this cannot be health insurance that involves premium tax credits on the exchange. So this is under Obamacare. This applies primarily to folks under that 250% poverty guideline. So the reality is that this final positive factor probably isn't going to help very many people. Because if you earn above 250%, well, then you're good to go for that reason alone. If you're earning below 250%, then there's a pretty good chance that you're enrolled in a program on the exchange, if you have healthcare at all, unless you're lucky enough to have it through a private employer. So certainly this is something you need to screen from, but my guess is that it's just not going to help that many people. Oh, Diana, so to answer the question of where I came up with this 250%, these positive factors that I'm talking about are straight from the rule. So it's the rule itself that defines them as heavily weighted positive and negative factors, and that 250% is codified in the rule. The only thing that is my spin is characterizing it as the safe zone. Okay, so that's all the multi-factor test and the positive and negative heavily weighted factors. An additional component of the final rule, which did exist in the proposed rule, is breathing life into public charge bonds. Now, it's already the case that INAs authorizes a consular officer or CIS adjudicator to impose public charge bonds. That's already in the rule. But it's just unheard of. I know it's been done in a couple consular cases, and I can imagine a couple chapter members who probably say that they, do it every second Wednesday. But I've never seen one of these, and I don't know of anybody who's ever seen them. In fact, CIS doesn't even have a procedure. If you want to walk into the Seattle field office with a public charge bond, you just can't even do it. DHS doesn't know how to process them. But that changes. So if you now have somebody who, makes it through the adjustment interview, and the adjudicator says, okay, you basically have an approvable application, except I'm finding that you are inadmissible on public charge grounds. And it's for people who are not far into the inadmissible zone. So if you're totally broken, have no ability to demonstrate self-sufficiency, this isn't going to help you. But DHS says for people who are in that kind of gray zone and just on the wrong side of public charge and admissibility, they will invite, in their great magnanimity, the ability for that person to submit a bond. So again, invitation only. It's a minimum of $8,100, although the DHS officer can set a higher amount. That's down from $10,000 in the proposed rule. And it's a cash or cash equivalent or surety bond. And the surety are those, it's called IRS Circular 560, I believe. Anyway, these agencies that are already certified with the US Treasury. A problem with that, so the rule authorizes these Treasury certified bonds. The problem is there's no consumer market for them, right? So if you Google, I would like to buy a public charge Seattle field office, you're not going to come up with anything because although these are legally authorized, there's no entity that's out there selling them. I don't know if that changes between now and October, but right now, I think you would have to get the money privately or there's not going to be a way to post these. Hey, Heather, to answer Heather's question, yes, having an ACA healthcare plan would be a positive factor as long as it's not one subject to tax credits, right? Okay, so these bonds are somewhat similar to the I-864 in terms of duration. They last until somebody becomes a citizen, has permanently departed the US, and by that, it means you have to formally file for renunciation of residency, or a person dies, or has been a resident for 5 years. They also end if somebody changes to a non-immigrant status, but that seems unlikely to ever happen, really. So basically, the bottom line here is normally they'll be in effect for 5 years. And you don't just automatically get your money back. You're going to have to affirmatively file for cancellation of the bond. The rules hedge a little bit on this, and they do permit DHS the authority to unilaterally refund the bond. So at least the possibility is left open that DHS might have a program to monitor people for hitting that 5-year residency, but it appears more likely that you'll have to actually apply for cancellation of the bond. So this is one that could be really problematic for our clients in application, because you're now going to have a situation where DHS officers have a ton of additional leverage over people in that most vulnerable category. And again, this is in the context of a rule that gives extraordinary discretion to DHS adjudicators. So, they're going to be able, if they want to use quite a lot of discretion to find factors somewhere in that cloud that put your client in the danger zone, adjudicate that they're public charge and admissible, and then require a bond for them to continue the process. And again, these bonds are going to be required per se by the immigrants who are least capable of paying them. Because if you have resources, you don't need a bond. Some potential takeaways, things to implement for your practice. One which I would commend to you, Jay Garrison's post on the listserv was pointing out that there are massive security implications, because on the I-944 form, you're going to be disclosing a lot of information about your household members. So careful about folks who may have background issues that they don't want coming up on the subsequent searches that are likely to be performed on their name. But again, go check out Jay's posts on that. He's the expert. Take home number one, obvious one, is file before October 15th if you possibly can. It means you are not going to be subject to the rules. One thing that I've started doing with my new engagement letters is giving clients a deadline and to say that, watch out, this rule is coming down the pipeline. If you want us to file your case before October 15th, which is a good idea, you must get us everything that we ask for no later than October 1st. If you do it later than that, we are not promising to file by October 15th. So that was my trying to think ahead about what is the middle of October likely to look like. Right, and so part and parcel with that is taking a look at your services agreement. Again, the I-944 form, guys, it's going to be a lot of work. It's going to be a lot of work. I think for a good number of cases, it'll probably be the thing that requires the most attention on the whole adjustment packet. My approach to this has been to parcel this off as an additional service. I don't know how long it's going to take to do this thing. So under our current engagement letters, we're saying, okay, we're doing our standard flat rate fee for adjustments, but whatever work is needed to complete the I-944 form, we just have to bill that on a separate basis, on an hourly basis, because we don't know what it's really going to take at this point. Moreover, this thing might get partially enjoined between now and October 15th. So to me, that's just a very uncertain environment. And I'd really rather not get committed to performing what I think might be a ton of work on a form that we're just unfamiliar with so far. As mentioned earlier, don't focus exclusively on those public benefit receipt factors, because there's a lot more to the rule than simply whether you've ever applied for public benefits. Excuse me. Number 4, as just kind of a rule of thumb, if you have a case with a joint sponsor, that's going to be a problem. It's going to be really a problem if you have a joint sponsor who doesn't have a demonstrated ability and track record, probably, of providing support to the family. But in addition to the fact that the rules now scrutinize that relationship, If you need a joint sponsor, it means per se that your family's income is probably below 125% of the poverty guideline. Because if it was higher than that, you probably wouldn't need a joint sponsor. So that's going to be a double whammy, that the family is low income and you've got a joint sponsor whose relationship will be scrutinized. So all joint sponsor cases are going to need a very close look. Given that credit score and English language ability are now taken seriously on the I-944, I suppose we might want to think about what remedial steps we might want to take with clients. So if you have folks who are pretty good with English language but never really took formal courses and you're not too sure how they'll do at the interview, those are applications you may need to delay. Or if they're, in that pretty close category, the type of folks that might be able to, pull it together for an N400 interview, you sure might want to think about getting them enrolled in courses in the lead up to their interview. And likewise, if their credit score is a real problem, you might want to delay the application and get them into financial counseling to get that credit score brushed up. The hard part here is that since this is, this vague multi-factor test, we don't really know how credit score is going to be weighed. Maybe it's something that your adjudicator just kind of glances over and doesn't worry about because your guy has a good employment history, or maybe they get really hung up on it and then you've got a problem and you're suddenly asked to post a big bond. Again, so especially with the Medicaid program, for example, folks are going to be asking you if they should disenroll their family. And those are decisions that could have really, profound health implications and well-being implications for the family. So, before you tell them in an overly cautious manner to disenroll, make sure that they actually are falling into a prohibited category. And at the top of this list is that receipt of benefits by family members is okay. So by all means, don't let your client disenroll their kids from food stamps in some sort of misguided belief that that carries public charge implications, because it doesn't. So make sure your families aren't starving themselves in light of this new rule. And finally, naturalization. I mean, when I look at this 19 pages of the I-944 form, there's a lot of information they're gathering from your client, and your client is going to be incentivized to put their best foot forward and to make themselves look as financially, solvent and capable as possible. Just don't let them exaggerate anything on that form, because then you're going to have a problem of illegal acquisition of LPR status. And I almost think that's part of the strategy here, is to give applicants even more rope that can later be used to hang themselves. So if they, exaggerate their employment history or salary, they might be looking at a fraud or misrep finding on the I-485, or maybe it gets caught later and they get an N-400 denial or get denatsed down the line. So we're just going to have to be really careful with this new form, assuming that it goes into effect. Okay, yeah, Laura, so on the issue of RFEs, and I should have mentioned this earlier, so the I-944 form is required as initial evidence with the 485 form. Totally apart from the public charge rule, of course, we have the new standard from CIS that says they can reject or deny an application that's deficient. So we don't know for sure how they'll deal with an application that's filed without an I-944, but they could just deny it under the new rule. But at any rate, you do need to be filing it with the I-485. And then, yeah, I assume that the RFEs are going to come if you've got somebody who's, in that middle zone of not clearly admissible. Okay, Danielle Roche asks, is public charge assessed at the time of filing or at the interview? In a pinch, can we file the adjustment of status and then have the client work on English? Yeah, so like any other ground of inadmissibility, I assume that the only adjudication of it will be at the time of interview. The caveat is only that you might get an RFE. I don't think that English language in particular would create an RFE issue, but if the totality of circumstances looks like there's going to be a low, looks like your problem, looks like your client has a problem. If your client doesn't have much going for them on the I-944, then you might get an RFE. I'll note also that I know from having seen FOIA results that Clinic got, that the adjustment of status form it was like a 65-page protocol for how DHS reviewed it. So as this form goes into effect, DHS is going to have a protocol at the National Benefits Center for how they review I-944 forms. And once we get that through FOIA, we'll have a better sense of what applications are and aren't likely to get RFEs. Devin says, I fear that CIS will start issuing RFEs to stop EAD issuance, similar to what you see if they think your I-64 is insufficient. Yeah, and that's ironic, right? So you'll get an RFE on your I-944, and then you won't be able to work. So then you look like you can't work. I'm going to go ahead and wrap up the recording on this. If folks have additional questions, you're welcome to shoot me an email on the listserv and we can keep the discussion going. If folks have pointers for how they're dealing with this, I would love to hear from you. I'm only primarily getting additional guidance from Clinic on this. And of course, they're dealing with a very different, super low income population than a lot of us are. So if folks have smart thoughts on how to implement this in our own private practices, I'd love to hear. Thanks a lot and wish everybody the best of luck dealing with this.